The jurisdiction fight disappearing changes the entire battlefield. Once Missouri is out, and both sides accept Kansas authority, there is nowhere left to hide behind procedure. The real fight becomes immediate, where these girls will live and attend school.
This is in the District Court of Butler County, Kansas, case entitled in the matter of Jeff Stiles Wick and Christina Hilton, case number 2026 DM 265. Beginning with the petitioning party in this case, could counsel announce appearances for the record, please?
Your Honor, Susie Locke appearing on behalf of Jeff Wicke, who is present in my office via Zoom. Also present in my office is a law student with our office this summer, Trey Myers.
May it please the court, appears respondent Christina Hilton via Zoom, by and through counsel Dakota Britt, who also appears via Zoom.
Very well. Thank you, counsel. This matter comes before the court at this time for further status review. The court noting that this matter came before the court on July the 14th. There was a question about between Kansas and Missouri, which court has proper jurisdiction. Apparently, the jurisdictional issue was under advisement in the state of Missouri at the time of that hearing. A status hearing was set for today, non-evidentiary, to determine jurisdiction status and possibly address start of school year custody issue on a temporary basis. Counsel was to advise the court of any Missouri ruling on jurisdiction. Counsel, let me inquire, has the Missouri court ruled on the jurisdictional issue?
Yes, Judge. I sent, it may not have made its way to you, but I sent an email a few weeks ago that case had been voluntarily dismissed, so there is no longer any sort of Missouri action pending.
All right. Is there a concession then by both parties that the Kansas court has jurisdiction of child custody and parenting time matters? Ms. Locke?
Yes, Judge, that's our position.
Mr. Britt?
Yes, Your Honor.
Very well. We'll proceed further. So I'm sure there's been some conferencing between Mr. Britt and Ms. Locke regarding this case and its issues. Has anything been resolved, Ms. Locke?
No, Your Honor.
Okay. So where are we?
Judge, both parties appear to be in agreement that the existing parenting plan is not workable. Mr. Britt filed a motion yesterday to modify the parenting plan. We had a prior motion on file, and I believe it is right for the court to make some sort of temporary order regarding the children's school for the 2026-2027 school year.
Okay. When does school begin in Kansas?
The Blue Stem starts the 17th, August 17th.
And the other school would be what school district and where?
My understanding is that it is Forest Park in Michigan. And that first day of school, I believe, is August 31st.
All right, very well. So there's a current disagreement as to where these kids are going to start school. A fair statement?
Yes, Your Honor.
Yes, Your Honor.
Right. In whose physical possession are the children now?
They're with respondent.
Okay, why don't we talk about father and mother and quit using nebulous terms like petitioner and respondent, counsel?
Yeah, of course, Your Honor. Yeah, they're with mother.
All right. I think I understand the mother's position, Ms. Locke, that she should be able to take the kids to the state of Michigan and have them start school in Forest Park, Michigan, August 31st. Your position differs.
Yes.
Why would that not be appropriate, Ms. Locke?
Your Honor, there's several reasons. First, the existing order that has now been registered in Kansas essentially states in paragraph 7 of that order that it is intended by the parties that mother would move closer to father, that her relocation would be closer to Leon, Kansas. 14 hours away is not closer than Kansas City. So the spirit of the prior order contemplated that the parties would still live close to each other. That's not only in that statement that it's intended that they would live closer to each other, but it's also throughout the order. The order contemplated that despite the change of residential placement during this school year, the parties would still transport by picking up and dropping off at the other person's residence. That the parties would still have every other weekend parenting time. That there would be a first right of refusal. Well, there can't be a first right of refusal when one parent lives in Michigan and the other parent lives in Kansas. So we believe that the spirit of the prior order was that the parties would live close to each other and both parents would be able to have meaningful parenting time during this potential transition. Furthermore, there didn't have to be a transition at all if mom moved closer to Leon, Kansas, and the kids continued to go to Blue STEM schools. The second point, Your Honor, is that the calendars of the two schools, which we provided an exhibit that overlays those two calendars, is not conducive to the parties having meaningful time with the kids, meaningful non-school time. The girls have established very meaningful relationships here in Kansas. They have a school community, they have a church community. The Forest Park School District calendar, if the girls came here for summer break, their classmates would be in school for half of that break. So because Kansas schools start so much earlier than the Michigan school district. So while the girls are here in Kansas, their grandparents who work at the school and their friends who attend school would not be able to see them. They don't have those same meaningful connections in Michigan. So they're not attempting to share their time in Michigan with friends, grandparents, other individuals. All they know in Michigan is mom, stepdad, and stepdad's family. So if the girls are in Michigan for non-school time, they get to spend all that time with mother. While when they're in Kansas, that time is shared between the intimate relationships and the people that they have met here, which reduces father's time, but also has this conflict with the school time. Additionally, Judge, the school breaks don't overlap. So, for example, spring break. If father had the girls on spring break, their friends that live in Kansas are in school during that period of time. And that issue is not the same if it's reversed. If the girls go to Michigan for spring break, mom gets all of that time with them, and there's no, it's not an obligation to share your time, but obviously you want your kids to be able to maintain connections with their friends, grandparents, etc. Mom doesn't have that same challenge in Michigan that dad faces here.
Father's argument is built around something stronger than mileage: practicality. His attorney attacks the Michigan plan by showing how a 14-hour separation could wreck the mechanics of the existing parenting arrangement.
We also provided several letters to the court. The letters are not being offered for the truth that's stated in the letters. They're only being offered to show that there is a substantial connection with the community here in Leon and the surrounding area. They have school connections, they're tight with their teachers, they're well connected with their church, they have a well-established community here. One daughter made the cheerleading squad for the middle school this year. She misses out on that opportunity. And it further shows that it wasn't contemplated that she would move. Why would she try out for the cheerleading team if she thought that she was going to go to Michigan and not be able to do the cheerleading at all? Their grade reports that were provided show that they have done well in Blue STEM schools. They have a track record of performing well academically. And so those are part of the reasons that we think that the court should find that it is not in the best interest of the girls to move them to Michigan schools. It's not in the best interest of the children that they are suddenly 14 hours away from the support system that they've known during the school year, the routines that they've known during the school year, all of the relationships that they've established during the school year. There's other aspects of the order that I would also, or the motion that Mr. Britt filed that I would respond to, that there's no factual or legal basis for the fees that he's requesting, and that there appears to be some issue on child support, but that is not properly before the court today. I think what we are asking the court today to do is to maintain the status quo in this case. The girls go to Leon schools, they go to mothers during the school breaks. That has always been that the parties have alternated Christmas break, they have alternated Thanksgiving break, and then mom has had the children for spring break and the entirety of the summer break. And we don't think that there's any reason to modify that at this time.
All right, Ms. Locke, a couple of questions for you. Doesn't the mother have a constitutionally protected right to travel and relocate?
She does, Judge. She does. The question,
And isn't a prior agreement of the parties on the issues of child custody and parenting time presumed to be in the best interest of the children?
2 points to that, Your Honor. Generally speaking, yes, but that would mean that the existing order was being followed by the parties, which it has not been. Mother never moved closer, so the parties have never followed this parenting plan. Mom's never had every other weekend parenting time. She's had the school breaks, and the parties have followed their own parenting plan, essentially. So that in and of itself suggests that the prior order was not in the best interest of the kids because they've completely modified it from before. Mr. Britt's position was that there was no basis to modify the provision of the school change, yet he is asking the court to modify the order to take out the every other weekend parenting time. So I think the parties are in agreement that there has to be a modification. Mom just doesn't want to modify the school, and dad also doesn't want to modify the school. He wants the girls to stay in Bluestem, and mom wants the girls to move to Michigan and go to school there.
All right. Mr. Britt, your response to Ms. Locke's arguments?
Yes, Your Honor. So the issue here is not whether the court would have fashioned the same parenting plan back in 2019. The issue here is whether there's a sufficient legal or factual basis to disregard an agreement the parties knowingly entered into 7 years ago after both parties have relied upon it and structured their lives around it. For 7 years now, dad has accepted the agreement. He has benefited from it, and he never once sought to modify it. Only now, when it is time for mom to receive custody that he agreed she would receive, he wants to contend that the agreement should not be enforced. This is ultimately whether their agreement should bear any sort of meaning whatsoever. This exchange was not an unforeseen event. It was the central feature of this parenting plan. The parties specifically agreed that father would exercise primary residential custody until July 1 of 2026. Mother would become the residential parent on July 1, 2026. This was not conditioned on remaining in the same state. It was not conditioned upon the children attending father's school district. It was not even conditioned upon mother living near the father. Everyone understood the transition would occur years later, and the relocation of the children was not an unintended consequence. Rather, it was built into the actual agreement. When they entered this agreement, the parties already lived in 2 different states. And in fact, it was actually father who moved out of Missouri further away from mother initially. At the time, mother was active duty military. They did not reside together, and she had actually communicated plans to relocate to Wisconsin before they ever even signed the agreement. There was no expectation whatsoever that she would someday relocate closer to father. To the contrary, there was every reason to believe that she would continue living elsewhere, including the fact that there was a order of protection filed in 2018. While that was ultimately dismissed voluntarily, it still showed an intent that she wanted to physically separate herself, not for convenience, but as for a matter of her own safety. Despite that, they still came to an agreement as to custody and what would happen in the future. This was a completely foreseeable event that both parties were represented by counsel during. Mom not only moved to Wisconsin, she later moved to Texas, and dad objected to neither move. Each move made it increasingly obvious that when July 2026 came around, the children would be relocating to mother's residence. If dad truly believed that the agreement required mom to live nearby or that the children were never intended to move, those would have been the appropriate times to raise that issue, and he did not. Instead, they did come to an alternative thing regarding the summers so that they weren't traveling and paying airfare all the time, but he never communicated that he did not intend to follow the July 2026 change in residential custody. This July 2026 was not arbitrary. There was a lot of discussion and intention that went into selecting that date. The parents had looked at the years of the children and realized that with that date, each parent would have raised the children for approximately half of their childhood. Each parent would have meaningful residential parenting time during different developmental stages, which was viewed as fair to both parties. Part of that being that the children, they have two daughters. The daughters are now approaching adolescence and puberty, and they agreed that it would be appropriate and in their best interest to be with mom during that time, while dad had the early years of their childhood, and they benefited from that experience with him. What's also worth noting procedurally is that while this was initially filed in Missouri and there was an objection to the relocation, no such objection has been filed here in Kansas. And when he dismissed that objection in Missouri, he effectively waived the objection.
Mother's attorney takes a completely different route: enforce the bargain. His argument is basically that father enjoyed the favorable half of this deal for years and now wants out precisely when mother's half becomes due.
The objection to relocation and never renewed it here in Kansas. So at this point in time, I would say procedurally, he has agreed to the relocation. When we talk about the school year calendar, they're actually not all that different. There's a reason only spring break was mentioned. Winter break is the exact same. Summer vacation begins at the same time and is actually 2 weeks longer when they're going to school in mom's school district. So dad gets an additional 2 weeks there towards the end of summer. The only meaningful distinction is that spring break is on 2 different weeks. That is hardly an extraordinary difference. Schools across Kansas and across the country operate on different calendars every single year. The calendar issue here is not what we believe is driving father's request. It's just simply the only remaining argument available once you acknowledge the actual custody agreement. When we look at this over time, chronologically, from the agreement all the way to today, nothing material has changed. The only thing that has changed is the agreed date has finally arrived. This is simply just an issue of the bargain that he made coming due, and he wants to benefit from his half of the agreement while not upholding the other half that he agreed to turn over. If mom believed this is how this was going to go, they would have gone to trial back in 2019. They wouldn't have had an agreed parenting plan. But she took him at his word, agreed to this, anticipating this to happen in the future. She planned for it. The children have been aware of it, and mom has structured her life around receiving this residential custody. Refusing to honor that agreement would create instability, not prevent it. The most stable outcome here is to honor the agreement that the parents made 7 years ago. So our request is that we would uphold the relocation. The status quo here is actually what they agreed to. That would be the status quo. We're open to making some adjustments with the summertime and things like that. Our counter motion to modify is actually for an eventual trial on this matter. It wasn't meant for today. And we acknowledge that traveling could be kind of difficult with the 3 weekends a month, the way that they have it laid out. And that's why if they want to argue status quo, it should work both ways. The custody change can happen and dad can get the summer parenting time that he was also offering to mom, and she's willing to do that. At the end of the day, worst case comes to worst, the parenting time during the school year is only weekend parenting time. If we have to make it work, we'll make it work. But dad should have to honor the agreement he made.
Weekend parenting time with one party living in Kansas and the other living in Michigan?
It wouldn't be ideal, but they can get on a plane and travel and get over there. We don't think that that's the most ideal situation, which is why we filed the counter motion to modify to address the weekend and summers and whatnot. And just at the end of the day, we think reversing the roles as they had originally agreed upon is what's in the best interests of the children, because nothing has changed about the circumstances of these parties.
May I respond, Your Honor?
Just a moment, Ms. Locke. Okay. Something I wanted to address you about, Mr. Brett, is your statement about objecting to the mother's move. He doesn't have any say over where she lives or where she moves to. There may be some rights to children affected by any move she makes, but I'm a little unclear what you mean about how somehow he's acquiesced in her move by failing to object to it. I think that this entire proceeding is his objection to her move. So
Yes,
what do you mean by that?
Yes, Your Honor. So the Missouri statute and Kansas statute and the parenting plan all would require that if she's going to relocate the primary residence of the minor children for more than 90 days, she has to provide that notice. And then he has to timely object and provide a good faith basis for that objection within a certain time frame. 30 days in Kansas, 60 days in Missouri. Nonetheless, doesn't really matter. That's what he's required to do. When I say that he has waived that objection of the relocation by not filing that objection in Kansas, that's what I'm referring to is the provision in the statutes where he's required to do so, because if he doesn't do that objection, then the legal presumption is mom may relocate the primary residence of the children, because that's deemed a consensual relocation of their primary residence at that point.
What was his deadline for this challenge, Mr. Brett?
So it would have been, I believe I believe the notice was given in June, because it's or May. It's a longer period of time in Missouri. So it would have been 30 days. It was 30 days afterwards. And he did timely make that objection in Missouri. That's not disputed. The issue was he dismissed that objection, but never objected here in Kansas. He only filed this motion for the emergency modification of the orders.
All right, Ms. Locke, first address that issue.
Your Honor, when Ms. Hilton provided her notice, first of all, I was not counsel and there was no Kansas counsel. But nevertheless, when she provided the notice, she was not the primary residential custodian of the children. My client was. The contemplated time in the existing order when that would change was July 1st. So prior to July 1st, we filed a motion to suspend her parenting time. She did not become the children's primary residential custodian until the children began to live with her, and arguably she's still not their primary residential custodian because this is that issue. And so I don't know how we could object to something that doesn't exist. We don't particularly care whether mom moves or not, but we are objecting to the change in primary residency to her, and we have done so in a proper motion before the court.
And I would say that the statute's very clear. It doesn't say, it says it's a future triggering event. If you intend to change the primary residence for a period of more than 90 days, that is what triggers it. It is built into the statute, into the Kansas statutes. It's also built into the Missouri statutes. His prior counsel was dual licensed in both Missouri and Kansas, which is worth noting. So he should have been aware of these things. It doesn't matter that she's not current, that she wasn't then at that time the primary resident. It mattered that that in the future she intended to change that for more than 90 days. That triggers the requirement to file an objection with the court, which they did not follow.
I'm
The fight gets technical, and the judge refuses to accept a convenient procedural shortcut. Mother's attorney argues father effectively lost his relocation objection by dismissing the Missouri challenge without properly renewing it in Kansas.
I guess I don't understand the argument, because we filed a motion to stay the move. And so if the move was stayed, the objection would have been moot and her notice would have been moot.
When was the filing here initiated, Ms. Locke?
Your Honor, we filed our petition on June 19th, and we filed a subsequent motion to suspend the change of residential placement and modify the parenting time. That was filed on June 23rd.
Well, Counsel, the first observation I'll make is that it would have been far more preferable that if there was going to be an evidentiary hearing to determine the best interest, the current best interest of the daughters involved in this case, that would have been conducted well before the intended start of any school. But that's not feasible now. I think at least partially because of this delay that existed in the Missouri court system before Kansas really can take child custody jurisdiction here. That certainly has contributed to this delay, but it bothers the court that I think the court is being asked for a ruling today, which essentially sets the tone for the entire case. Because quite frankly, where these kids start school very well could be where they eventually end up. So without the benefit of a full evidentiary hearing, the court is being put in a position to make a decision which will have a huge impact on the eventual outcome of this proceeding. Ms. Locke, do you have any additional remarks or argument that you wish to make?
Judge, only related to Mr. Britt's comments. Mr. Britt is focusing solely on this one provision of the parenting plan. And his position is that this issue that my client is raising is precluded because it has never been raised before. The parties have never followed the parenting plan as it exists on paper today. So the idea that he would have objected prior to now, when the change was supposed to occur, is inconsistent with how they've operated. They've never had every other weekend. They've never had the first right of refusal that was in this existing parenting plan. They've never followed the existing parenting plan. So he had no reason to believe that suddenly they would start following it when it was favorable to mom. He didn't know that her moving to Michigan or Wisconsin or her moving to Texas was some statement that she would be moving to Michigan when it was time for her to have residential placement of the girls. I mean, the parenting plan itself states very clearly that it is the intention of the parties that they would reside closer to each other. Why put that in there if that was never the intention? So this sense that this order has to be filed, only the part of the order that has to be filed or followed is the school year change is inconsistent with how the parties have operated since this decree was filed. So we are asking the court to find that there is no issue preclusion, which Mr. Britt seems to be arguing. There is no objection that we failed to raise, so we have waived that point. There was no waiver by my client at all. Rather, he has regularly and consistently parented the children, that he has been the primary school parent, and that it is not in the best interest of the children to modify that. And that is the prevailing question before the court, is what is in their best interest? And it is our position that it is in their best interest to maintain the status quo, which is attending Blue STEM schools.
Mr. Brett?
Yes, Judge. So this best interest analysis, this was all taken into consideration when they entered an agreement. Dad and mom both agreed in 2019 that a change in custody was in the children's best interest on July 1 of 2026.
How do two parents realistically, 7 years in advance, make a determination with all of the development and maturity of these children over a 7-year period and decide responsibly that this change can be made on a certain date 7 years later? I mean, I think that the court scoffs at the notion, Mr. Britt, that they could look into a crystal ball 7 years ago and determine exactly what was in the best interest of these girls as of July 1 of 2026. But that's essentially what your client's argument is. Well, it's on paper and I wish to enforce it, and that's the end of the story. I think that oversimplifies the issue, doesn't it?
I understand where the court's coming from, but as I addressed earlier, they had taken a variety of factors into consideration. They'd taken the age of the children into consideration. They'd taken into
Okay,
consideration
is
the
that
age.
is that weighed in the agreement? Or are you saying that these factors are set forth in the agreement and weighed in a manner for which this court could review it? Or does
No,
you just think that it probably was before that clause was drafted?
those are the discussions that were being had as the clause was being drafted, as the parenting plan was being drafted. That's what the parties themselves were discussing with each other. And so that's how the agreement came about. We understand this is an unusual scenario in most parenting plans, but this is what they talked about and what they decided that they thought was best at that time. And now dad wants to go back on that agreement after he's received his half of all of the benefit. And the point of the prior relocations, the point was she never, this issue of them potentially being in another state has always been on the table, always been at the forefront, because she did live in 2 other states. And it would have been more prudent for dad that if this was actually his true concern, to file a motion to modify the first time she moved further away, where we wouldn't be at the eve of school starting in 2 weeks and all of a sudden he wants to hash out something because, again, the day of exchange is finally here. This is a buyer's remorse situation. He's unhappy with the agreement that he originally made, not that he necessarily believes in good faith that it should be changed.
The judge identifies the biggest problem in the entire case. Timing has forced him toward a major decision without a full evidentiary hearing. Where the girls begin school could heavily influence where they ultimately remain, making this supposedly temporary ruling incredibly powerful.
May I respond just briefly, Judge?
Very briefly.
This isn't the refinancing of a marital home. These are 2 children who have interests, who have needs, who are living, breathing human beings with emotions. Their interests have changed, and the court and mom need to take that into consideration when making a determination as to what's in their best interest. Up and moving them 14 hours from the only home and school they've known is significant. And it's not buyer's remorse. It's a father who is concerned about the well-being of his kids.
The only thing I would add to that, Judge, is he's making those as a concern now, but why was it not a concern 7 years ago when he made this agreement? He should have been able to think forward into the future and say at that time, hey, actually, I don't think this is a good idea. We don't know what's going to happen in 7 years, so maybe we shouldn't agree to this. But no, that's not what he did. He said, I think that this is in their best interest definitively, even though I understand things may change in the future. This is what I'm agreeing to, and this is what I'm promising to happen with the children at this future date. And that should not be overlooked.
Respectfully, Your Honor, that is exactly why we have motions to modify parenting time, because parents enter into parenting plans that become unworkable and unreasonable, and they are allowed to bring that issue back before the court so the court, as a neutral third party, can decide what is in the best interest of the children.
Except not in all parenting plans does a parent detrimentally rely on that future promise. Had my client known he was going to go back on his word and took him at his word as a man, if she knew this is where we were going to be today, they would have gone to trial in 2019. And who knows who would have gotten primary custodian at that point in time.
Wasn't she active duty military back then?
She was at the time, but she had been relieved from duty only a couple months after the divorce had been concluded, because during the divorce proceedings, she was getting out of the military at that time. Believe their decree was signed in August, and I think she was out of the military by the end of September.
She had the opportunity at all of these chances to move closer to her children. to engage in meaningful parenting time with them, every other weekend parenting time, every other school break. And it has been mom's decision alone to move to Wisconsin, to Texas, and now to Michigan. My client has been the only parent that has lived in Leon, been stable and consistent since even before this divorce was finalized.
So even though a Missouri court case was pending, he moved to Kansas during the pendency of that case?
Correct, Your Honor, and that was by agreement. His parents live in Bluestem or live in Leon. And so during the pendency of that case, he moved and the girls moved with him.
This is not the first case that this court has handled over the years where relocation of children was an issue prior to school. In other words, the choice of school district. The court can say unequivocally that under normal circumstances, this court would be highly inclined just simply leave things exactly as they are, preserve the status quo until the matter can be fully and fairly litigated. The complication with that in this particular case is a specific clause in the party's prior divorce decree, which essentially stated that on a date certain, primary custody was going to change. It is argued, at least by the mother in this case, that essentially that was a license for her to move anywhere, no matter how far away, regardless of any disruption of the father's parenting time that might be involved, and establish custody in another state. The court is troubled by this. This court at this time would consider their agreement 7 years ago to be ill-advised and not necessarily consistent with the future best interest of the children. Again, as I challenged counsel with the court's question, how could they determine 7 years ago what truly was in the best interest of their daughters? Now, they can make an agreement between the two of them, which they consider to be in their personal best interest, but ultimately the court has to decide what's in the best interest of the girls involved in this case. I'm in no position to be able to ascertain their position with any certainty today. Rather, this court is asked to make an initial determination as to what happens at the start of this particular school year. And this court will conclude that until this matter is fully and fairly litigated, the status quo regarding school district and school residency should be maintained. So the court at this time will enter a bar to enforcement of the parties' 7 years ago agreement, and instead order that the father have continuing primary residential custody of both children and may enroll them, and that they are supposed to start on the first day in school as scheduled in the Bluestem School District. With that said, it is not unprecedented for kids to change schools in the middle of a school year. I find that generally undesirable, but it's not unprecedented, and it isn't necessarily going to affect their long-term educational progress to change schools should the court reach a different conclusion following the trial of this matter, which in this case seems bound for trial in this particular case, unless the parties reach an agreement otherwise. While the court recognizes that these parties did enter into an agreement 7 years ago, that is presumed to be in the best interest of the children, that presumption can be overcome. And the court believes that based on the presentation made by the father in this case at this juncture, that the court should find that presumption at this point has been overcome or is likely to be overcome, and therefore the court will make the ruling that the children stay where they are for now. Okay. Ms. Hilton, you have your hand up.
Stay where they are.
In other words, as far as the school district and school residency is concerned, they stay with their dad. Now,
Okay,
if
I'm
you're
con-
exercising a period of parenting time up to the date of start of school, it's not the intention of the court to interfere with that. I
Understood.
presume they
And
don't have to be back in dad's home prior to the first day?
yeah, oh, so the house that they reside in, when he moved in with his parents, is still his parents' house. I don't think he can afford to get them back into his care. Am I responsible to pay their way back to that school so that they can be there in school? I paid to pick them up. I've always paid for the travel, but I don't think their father's in a position to be able to pay for their return.
The judge openly acknowledges that his normal instinct would be preserving the existing arrangement until a full trial. The unusual 7-year-old custody clause makes that harder, but it does not control him. His reasoning effectively separates parental promises from judicial responsibility.
Ms. Locke, it's a fair question. Your answer?
My client will collect the children to ensure that they are ready for their first day of school at
And
Bluestem.
what does that mean?
He will
Collect
either
the
come
children.
and he will most likely come to pick them up, Judge.
Likely through his own automobile?
Yes.
He'll drive up
Correct.
here, pick them up, drive them back? Is that what's
Correct.
Yes,
contemplated?
sir. Yes.
All right, then. When does that exchange have to take place to get him in school on time the first day?
Your Honor, our proposal would be that the exchange take place on August 15th. It's a Saturday. That way they can drive home on the 16th and be at school on the 17th.
All right, is there a response to that suggestion? Ms. Hill?
Christina.
Just very briefly, is there a point to ensure that the vehicle is properly insured and registered? Because I have concerns about that as well within that household.
So Mr. Wick traditionally drives an illegal vehicle? Of course, it should be properly registered, safe for the girls, and insured properly. Ms. Locke, is that a problem?
Not to my knowledge, Your Honor.
Okay, my only question, and it may be something Ms. Locke and I have to work out after this, is there's a lot of talk about the status quo. Because of these proceedings, generally in past summers, my client had gotten the children on June 1st, but Dad wanted to follow the parenting plan all of a sudden with the July 1 date. So my client's now been deprived of an entire month of parenting time because of the way he handled himself in these proceedings. And I would like to have some sort of recourse for that, because that's not fair, not just to mom, but these two girls.
Well, what do you suggest? The summer's almost over.
Perhaps we make it up on some of the upcoming extended breaks.
Well, that would seem logical and fair, Mr. Brett, but again, not being fully aware exactly how you would do it. Again, I would ask you to talk to Ms. Locke about that. I think court generally looks favorably on your position, Mr. Brett. Okay. Ms. Hilton, again.
Yes, I just want to verify that the court has agreed that the best interest of the children is to foster their relationship with their friends and their father, and that the meaningful relationship with their mother is in this
The
point.
court made no such finding.
Thanks, I misunderstood.
All right. Everyone's gone silent, and perhaps that's intentional. I just got a message that my internet connection appears to be unstable, so hopefully you don't lose me.
We
And I don't
have not
see that there.
experienced
Ms.
that.
Locke, you're going to be tasked with journalizing today's proceedings. It should be a simple and straightforward order.
Understood.
However, if you and Mr. Britt can reach some sort of accord on this makeup time, which again, the court looks favorably on that request, you could include that. On the other hand, we also have to look at what the future course of this litigation will be and to establish a proper time schedule for its ultimate resolution. So with that said, what kind of trial date are we looking at here, counsel? Ms. Locke?
Your Honor, I would contemplate a one-day trial on the issues.
And when are you going to be ready for it?
No discovery has been issued, Your Honor, so we would ask for at least 60 days so that we can issue some discovery.
And in the meantime, your client remains in control of things.
That's correct, Your Honor, but Mr. Britt also hasn't issued any discovery. And so I'd imagine that he will want that same opportunity to ask questions of my client.
I also presume that there's some actual need for discovery in this case. Right offhand, I don't know what that would be. Counsel perhaps being more familiar with the facts and circumstances of this case, maybe you already have some sort of discovery in mind, but all right, Mr. Britt, your response?
Yeah, I would agree. I would want a little bit of time to do discovery. So I don't want to set this super far out. I think 60 days to get discovery drafted, exchange and whatnot. 60 days is probably the shortest amount we could really do here.
And we'll assign that date now. That puts us into the month of October. Also, would you look at your calendars for Thursday, October 15?
I could do that.
Ms. Locke?
Judge, I don't have the full day. I have something at 2 o'clock, but I am otherwise available.
And can you move to 2 o'clock?
It's a soccer game and I happen to be the head coach for the high school. Sorry.
I understand. I'm hesitant to use this date because it follows a court holiday, but I could also offer Tuesday, October the 13th.
That works for my calendar, Your Honor.
So Britt,
I can do the 13th.
very well.
Judge,
9 o'clock, Courtroom B, Butler County Judicial Center, El Dorado, Kansas. This is an in-person proceeding. Ages of the girls at this point? Somebody?
10 and 12.
10 and 12. Is there going to be a request for the court to interview these girls? Ms. Locke?
Yes, Your Honor.
Mr. Britt?
Yes, Your Honor.
All right. I will do that first thing. And then hopefully one of the parents can have some substitute care available to get them out of the courthouse and in some back to school, perhaps. I think that's probably the father's responsibility at this stage to get them there at 9 o'clock and then have somebody drive them to school after the court's interview, which would be at 9 o'clock a.m. on Tuesday, October the 13th.
Your Honor, my daughter has already advised me that she doesn't feel she can answer truthfully if asked in public and would like to speak to a third-party mediator or professional in a private setting.
Why are those conversations even happening?
My daughter and I have a very close relationship. Please stop questioning me.
The court will conduct the interview.
No,
The interview is in chambers. I want to make sure that it's clear for the record that this isn't going to be an open courtroom type of thing. This is going to be a closed proceeding. The court and its assistant.
After losing the immediate school issue, Mother shifts toward implementation and fairness. Her question about return transportation forces Father's side to prove that the ruling can actually be carried out, and his attorney commits to getting the girls back for school.
Assistant will be conducting the interviews in chambers. So I've done this successfully many, many times, and I feel quite capable of handling it with children that are 10 and 12.
I just want to make sure I understand. So the interview will happen that morning at 9 a.m. first thing, and then afterwards, someone will drive them back and we'll resume with the parties in the courtroom.
Correct, Mr. Britt.
Okay. And could you give that courtroom number again?
Courtroom B,
Courtroom B, that's what I thought.
the Butler County Judicial Center. Obviously, I will expect exhibit notebooks and witness list turned over to the opposing party in advance of that hearing. I need that done by no later than noon on Friday, October the 9th. You can certainly send them sooner than that, counsel, but I want to make sure that your exhibit notebook and or witness lists are in the hands of the opposing counsel by noon, Friday, October 9th. You can present your exhibit notebooks to the court at time of trial. as we're doing it in person. And yes, you may send to opposing counsel your exhibits electronically. But the courts are on paper. All right. Yes. Again, Ms. Locke, if you'll include these pertinent items in your order stemming from today.
Judge, may we have a provision in the order that states that the court's interview is not to be discussed between the parents and the minor children?
The fact that the court's going to conduct an interview,
The nature of the
I
interview.
would generally give that admonishment. I think I understand your concern that the parents aren't to work on the kids to tell them what to say.
Correct.
Well, I don't think the parents are going to know what I'm going to ask them or how I'm going to handle it. So I do believe that it's appropriate for this court to direct the parties that they can prepare them by saying that the judge wants to speak to you and he will interview you prior to this. I think they're aware of the custody dispute that's taking place between the parents, but they should not elaborate any further. I don't want these kids inappropriately influenced. Anything that I receive from them, I want it to be their thoughts, not their parents. They shouldn't be put under any pressure whatsoever by either parent in the case. All right. All right. The court certainly appreciates the diligence and the quality of the presentations made by each of the attorneys today. This is a difficult situation and a difficult case. The court's made its rulings today, essentially believing that these current orders are consistent with the best interest of the kids at this stage. Further determination will be made later regarding their future. All right, Mr. Britt, anything else we need to address from your perspective?
No, Your Honor.
Ms. Locke?
No, Your Honor.
I hope that over the next few weeks, the parents can continue to work together for the best interests of both of these girls.
The scheduling discussion reveals another hidden power imbalance created by temporary orders. Father keeps residential control while both sides prepare for trial, meaning every extra week potentially strengthens the status quo he just preserved. The judge notices that reality when discovery time is requested. Still, both attorneys agree they need roughly 60 days, and the court moves toward an October trial rather than letting this drift indefinitely. Then the daughters themselves become central. At ages 10 and 12, both sides want the judge to interview them. That changes the case dramatically because the court will no longer be hearing only competing parental interpretations of what these children need. Their own perspectives can enter the analysis directly. The judge plans a private chambers interview before the courtroom proceedings. That structure reduces the performative pressure of open court and gives him a chance to evaluate their views without either parent controlling the conversation. Mother's statement that a daughter already fears she cannot answer truthfully triggers the judge's sharpest concern. Why is that conversation happening at all? The issue is bigger than whether mother believes she is protecting her child. Once a parent discusses how a child might speak in a custody proceeding, the court has to worry about influence, pressure, or rehearsed answers. The judge responds by taking control of the interview process and making clear it will happen privately in chambers. Later, he goes further. Both parents may tell the girls that the judge wants to speak with them, but they should not elaborate or prepare substantive answers. His objective is clean evidence. He wants the children's thoughts, not parental strategy coming through their mouths. That could become crucial at trial because credibility now extends beyond the parents' competing stories. The court is actively protecting the daughters' voices from contamination before making the final custody decision.